everybody. Good Saturday afternoon here. Welcome to Weekend Appointment. This is the show where we answer your legal questions. 540-0580. It's 540-0580. I'm an attorney at law, as regular listeners know, and those of you who are joining us for the first time, I practice throughout the mid-state. I can only answer questions on Pennsylvania law. But if you have a legal question, you want to talk about divorce law, child support, personal injury accidents, and I want to touch base on personal injury for a moment. A friend of mine called me, and he says, hey, I was in this accident, and the insurance company called me, and, you know, it's been a while. I'm not really hurt that bad, and my back still hurts a little bit, and it's been 3 months, but hey, they want to give me like $2,500, and they said, you know, if I want a little bit more, they would do that, so I'm going to do that. I just thought I would check with you. And I said, what are you doing? Why on earth would you do that? And he says, well, you know, seemed like a good amount of money. And I said, hey, you're thinking with your own pocketbook, not the insurance company's pocketbook. Again, talk line number is 540-0580. The point is, and the reason I'm giving you this story is he's so undervalued his claim. When I started to look at it, I said, they should be paying you about $25,000, not $2,500. So I'm going to help him out with that. And my whole point in telling you is just that if an insurance company is trying to hand you money, be suspicious, because usually, even when you have a good claim, they want to, nickel and dime you to death. So the fact that they're trying to get you to sign a quick release for $2,500 should send a signal to you. So folks, no matter how clever you think you are and how much experience you think you have settling your own injury case, which for most of us would be about one time in our lives, you're going to learn that what the value of your claim is a lot of times less than or more than you think, and I find most people undervalue their claim. So a reminder, you won't save money by settling your own claim. You'll make more money by paying the attorney fee generally. 540-0580. Charles, you're on WHP 580 with Carl Rominger.
Yes, Carl, I called last week, but I have a whole different question for you. I have to go to a preliminary hearing about someone that stole my cell phone. What do I need to take to show evidence that he's took my phone? Like, how do I prepare myself?
Well, you won't be conducting the hearing, meaning the police officer will be calling you as a witness. So you should contact the police officer or the prosecutor and ask them if there's anything they want you to bring. If you do have some documents that would prove you own the phone, for instance, maybe a bill in your name with that number on it or a receipt for the purchase of the phone, that might be helpful. But again, it's up to the prosecutor to tell you, if it's just a police officer, to tell you what they want you to bring. It's their job to prepare their witness.
No, they didn't. I just got a thing from a district justice to go to 501 Mall Road for a preliminary hearing.
Which is the prison, by the way. You get to go to the prison for the preliminary hearing. But go ahead and call the police officer who brought the charges and say, you need me to bring anything, and they'll help you out.
Okay, cool.
All right.
Thank you very much.
All right, good luck, Charles.
Thank you, brother.
Folks, when you've been subpoenaed as a witness, hopefully the lawyer or the Commonwealth, whoever subpoenaed you, will tell you if they want you to bring anything. And a lot of times the subpoena will include, we call it a subpoena duces tecum. And in that type of subpoena, I will list, hey, and bring with you your appointment book or bring with you any documents related to account number such and such, etc. So generally a subpoena that wants you to come and bring certain documents will also include the documents you want. But hopefully whoever's calling you is going to prepare you. Again, 540-0580. And I want to remind everybody, go to weekendappointment.com throughout the week because we're going to take a few calls, or take a few questions, rather, from weekendappointment.com. Folks post questions on there, and I answer them throughout the week, and I save some for the show. John, you're on WHP 580 with Carl Rominger.
Hi, Carl. Thanks for taking my call.
No problem.
In the 07-08 season, I had prepaid for heating oil.
Okay.
And during that year, my heating delivery person went out of business, and he actually went bankrupt. Now, this year, early spring, I got a letter saying he was liquidating his personal assets, and I would be getting the rest of my money back. I was just wondering if there's anything I can do, or if that's it.
The letter you got, was that from the bankruptcy court?
No, that was from him personally.
From him personally. Well, he let you down once. I hope maybe he's not going to let you down twice.
Right.
And maybe he's trying to make it right. But I would check and see what's going on with the bankruptcy and see if you need to file any kind of notice of claim with the business bankruptcy or what's going on there.
Okay. It isn't an awful lot. It's like $700-800.
Right.
But it's
right. And you don't. But you don't want to spend a lot of money on it. But
right.
like I say, I would try to find out from the bankruptcy court. They usually post those online, and you can find that. If you get a chance, feel free to call my office. You can find the contact information on Weekend Appointment. Just ask for Lee and run a quick question by him. He might be able to tell you the quickest and easiest way to check on a bankruptcy.
Okay.
All right?
Okay, thank you very much.
All right, thanks, John. Good luck.
Thanks.
Catherine, you're on WHP 580 with Carl Rominger.
Hello, I have a question about will or lack of will and property ownership.
Okay.
My husband and I own a property in both our names, and if one of us should pass before the other, does it go right to the other person?
Assuming you're owning it, because here's why. Even though you're husband and wife, you still have to make sure that the property is titled correctly. And so when people say it's in both our names, I don't know if that means tenants in common or tenants with right of survivorship or joint tenants in the entirety, which is the magic word for married couples. Generally, you want to own things as joint tenants in the entirety.
Okay.
If you own it as tenants in common, then no, it doesn't automatically flow. But there's no reason. Now, whoever did your deed, if they did it for you and had half a brain, would do it as husband and wife. But
Okay.
there are times that, people let the realtor write the deed or they write it themselves and that person doesn't really know what they're doing. And again, that's why I like to see lawyers write deeds. But
Okay, and there is another property then that he owns with his brother.
And that is, again, depending on how they own it. If they own it as right of survivorship, then whoever lives longer owns the whole thing. If they own it most commonly as tenants in common, or most likely as tenants in common, then that means they each own a 1/2 undivided interest. And so if one of them dies, half of it still belongs to their estate, and therefore that would go to you through the estate unless he writes you out of the will, and then you got to take against the will and blah, 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 blah.
So both of them have to actually be checked on to make sure they're written properly.
Yes.
Okay.
All right?
That's all I need to know. Thank you very much.
All right, good luck with that.
Thank you.
And as a jumping off point, you would hope that whoever wrote the will or wrote the deed for a husband and wife would do it correctly. But folks, if some guy in a transaction says you're buying some property and they say, well, we'll give you the deed, and you didn't get an attorney involved to represent your interest as the buyer, because the attorney's going to explain all that to you. Sometimes people go with title companies. Sometimes people go and let the realtors do it. And I know some title people and realtors go, oh, you're bashing. I'm just not bashing you. I'm just saying there are decisions that need to be made about how you want to title that property, and an attorney can kind of jump into the broader realm of how and why to do that. Patty, you're on WHP 580 with Carl Rominger. My talk line number is 540-0580. Patty.
Hello?
Yes.
Okay, I'm here. I've been in 2 accidents. One was August 27th of last year, 2008, and then I was in an accident February 5th of 2009.
Okay.
In both cases, I was hit from behind. First one, I was stopped at a stop sign. Somebody just plowed into the back of me. The second accident, I was turning into a shopping center. It was like an ease into, and a guy missed the stop sign and hit the back of the car. I don't have a lawyer at this point.
Right.
The last accident, they took me to the hospital, an emergency room. The first accident, I went to my family doctor. Now, I'm still going for physical therapy. Well, the first one I was going for physical therapy, and then I got hit again, so I just continued with physical therapy.
Here's your problem, Patty. Let me tell you 2 things. First of all, remember you have a 2-year statute of limitations. Otherwise, you lose your ability to bring any kind of claim. So you got to put that in the back of your head.
Okay.
Number 2, each insurance company is going to try to blame the other accident as the primary source of the ongoing injury. And untangling 2 simultaneous accidents like that takes a very careful knowledge of both medicine and the law, because you can collect damages, for instance, if you have a prior existing injury which has been enhanced or re-aggravated, the second person would be liable for that. And the first person would be liable for the injury itself, although there's an argument that they may also be liable for the re-aggravation as well, because you wouldn't have had a re-aggravation of that injury in the first instance if they hadn't done that to you.
Right.
But basically, you have to very carefully sort out the medical evidence and make careful arguments with each insurance company. And, again, and maybe you heard me earlier, I don't believe that people should be handling their own personal injury cases, because They are complicated, and they're complicated to the point where I have to sit there sometimes for hours and do research and think long and hard about how to present something to maximize the value. And I don't know how a person who doesn't have experience in that area would pick a value, let alone sort it out between two insurance companies over two different accidents.
Well, the second one came right out about less than a month and offered me $1,000 to sign off right then and there. She said, we acknowledge that
Right.
our gentleman was at fault.
Right.
And if you take it right now, I'll give you $1,000 and that'll be it. And I said, no, I want to feel better before I sign anything.
Yeah, and how do you know if it's worth $1,000 or $10,000 or $15,000 or $100,000?
Right. Well,
So
I don't know. I wouldn't think 100,000, but
I wouldn't think 100,000 either. But Patty, you know what? Get a lawyer.
okay.
Get a lawyer. Don't sit on this. Get a personal injury lawyer. If you go to weekendappointment.com, you get my contact information. But make sure you get a personal injury lawyer.
Okay. There was another question. My daughter. I was in my daughter's car the second time. I was going to pick
Yep.
up something for her, and the insurance company is not wanting to pay for the February 5th one is not wanting to pay for her damages done to her car.
Oh yeah, the lawyer needs to talk to you about that as well because somebody needs to pay for it.
Yes, we've gotten estimates and everything on it, and they're refusing to call her back or anything.
Yeah, yep. Now you need a lawyer for two reasons. Then,
Okay.
Patty, get a lawyer.
Thank you.
All right, good luck.
Bye bye.
I got to go to break. 540-0580. When I get back, we'll talk with Tony. Hey, welcome back. Carl Rominger here. Show's Weekend Appointment. Don't forget to get your free will at weekendappointment.com. Folks are coming into my office. We're meeting. We're filling out wills. We're doing it just like you paid hundreds of dollars. So go to Weekend Appointment, become a registered user, go to the free will section, download the forms, fill them out, and send them in, and you get the free will. Anthony, you're on WHP 580. My talk line number is 540-0580. What's your question, Anthony?
Hi, Mr. Rominger. I have a question about a divorce proceeding.
Okay.
There was a legal change of name by the other party during the divorce proceeding. How would it affect the divorce proceeding?
Legal change of name during the proceeding.
Yeah, the other party changed her last name.
Okay. Doesn't make a difference.
Okay, there's no effect then.
Should not have any effect whatsoever. In fact, the only way you can change a name is with a court order. So I would presume that they made the court aware of the pendency of divorce, but it doesn't change who you are.
Okay, well, I know that the prior name no longer is valid anymore. It can't be used.
Well,
when it's changed.
Right. Once you change your name, the old name's no longer valid, but you would just sue the divorce is against, but it's the same individual. So the caption, usually what we would do is just keep the caption the same, and then in parentheses we just put, now such and such, or if we filed a divorce afterwards, we put the new name in and we put formally such and such.
Okay, that was simple.
Yeah.
I have a second question about a motion. I don't know. See if you can answer this. I was sent a motion by the other party that wasn't verified. At the hearing was continued.
Right.
But I filed an answer in a cross motion.
Okay.
And there was a second hearing scheduled. And at the second hearing, the judge went over my answer in cross motion, but there was no motion by the other party presented or filed.
Okay.
Their motion was contained as a copy within my answer in motion.
Okay.
First of all, their motion not being verified, doesn't it make it null and void?
Not really. You got to object to that and ask, complain that it's not verified, and theoretically it should be, but that's not a huge defect. I mean, it's not fatal unless you make a big issue out of it.
Okay, I thought it was an essential element.
Nah, you're. It sounds like. Let me tell you what's going on here, Anthony. I like answering your questions, but I'm going to tell you what your problem is. You're representing yourself, right?
Correct.
Yeah, and now you're all worried. You're doing what all the guys and gals who represent themselves do, which is getting bogged down on these rules. And you got to follow rules, and some rules are fatal and some aren't. But that's what a lawyer knows off the top of their head. And some things are worth making issues out of, and some things aren't. And there are times when somebody doesn't verify something or they forget to, and I call the other lawyer up and I say, "Hey, Bob, you forgot to verify that. Can you get me a verification?" "Well, I ain't going to verify it." Okay, well, then maybe we make an issue out of it. Or I just don't even notice it, and we get to court, and there's an attorney's verification instead of the individual's verification on it. And there should have been individual. Who cares? Get the case done and over with. Get the dispute solved. Getting bogged down in the technical stuff, that's just a sure sign that you don't really know what's going on. All right?
Yes, I understand. Thank you.
Think broad stroke, think big issues. Yeah, folks, if you're going to, that's why I hate going to court with people who represent themselves. They're like, well, you didn't comply with Rule 102B subsection 6. And the judge and I are looking at each other like, what rule is that? Well, first of all, half the time it's the wrong rule. And second of the time, they misunderstand the rule. And a third of the time, it doesn't matter because there's no remedy. The failure to comply with the rule doesn't mean anything. And maybe the judge gets mad at me and says, hey, you should have done this or you should have done that. But aren't we just here to figure out what the custody of the kids should be? So shouldn't we just kind of deal with that while we're here? So, folks, don't represent yourself in lengthy litigation pieces. And if you do, stick to the broad, important stuff instead of trying to get your ex thrown out of court because they didn't cross-verify the third line of the second motion. Sarah, you're on WHP 580 with Carl Rominger. My talk line number is 540-0580. Are you there, Sarah?
Oh, yeah. My daughter's name is on my deed.
Okay.
If something would happen to her before me, would I have to pay for half of my house back?
I don't know. I don't know how you put her on your deed. Did you put it with right of survivorship?
I don't think so.
Well, then she would own half of the, if you put her on the deed, then she owns half the property.
Right.
And if you put her on as tenants in common, then yeah, that's hers, and then her estate would dispose of that. So she could leave it to somebody. Maybe she wants to leave it to me. I don't know.
Oh.
Then you and I would own it together.
So what are you telling me?
I'm telling you that if you put her on your deed, but why? You probably put her on her deed with right of survivorship for either side. That's usually why we put our kids on a deed, so that if something happens, it automatically becomes theirs. So I'll bet if I read the deed, you're going to find out that whoever lives longer owns the whole thing. But you got to look at the deed.
So then I wouldn't have to have her name taken off.
Right. But you need to have a lawyer look at that deed and tell you what it says. Answering questions about deeds, and let me explain this. Without you having the deed in front of you, being able to read, owned by Sarah and her daughter as tenants in common, or owned by Sarah and Sarah's daughter as joint tenants with right of survivorship, without knowing that magic language in there, I can't really tell you the exact effect. So you need somebody to look at that for you.
Yeah, that's what's the matter. I'm too dumb to read it.
No, you're not too dumb to read it. It's that some words have, what does joint tenants in the entirety mean, Yeah. I had to go to law school to learn that. I didn't know that. And I still wouldn't know it if I hadn't spent $1 billion on a legal education.
Oh, boy. Well, then I guess I'll have to get it out and get it to a lawyer.
That's right, Sarah.
Okay. But is it true that if it's not wrote right,
you might end up...
I would end up having...
Yep. You might end up buying back that half of the property.
Okay, that's what I wanted to know.
And Sarah, well, I got you, and I'm gonna let you go, and then I'm gonna rant a little bit. But turn your radio back up and take a listen to what I got to say, okay?
Okay.
All right, Sarah.
Thank you.
All right, Sarah's turning her radio up right now. So my talk line number is 540-0580, 540-0580. And what was I going to rant about? Well, what I was going to rant about is this. Everybody wants to add their daughter to their deed, add their son to their deed, put so-and-so and do this and bank account that and, engineer everything to make things simpler. But don't do that willy-nilly. Get an estate planner like an attorney or a financial advisor of some sort. I got this Decker guy that's on before me. Get together with somebody, and it's best to use an attorney in my recollection, and the attorney can point you to other people, and work out a plan, because we run into cases where people add people to bank accounts and then later on create tax burdens that wouldn't have existed, create property issues and need to buy things back, just like Sarah was worried about, that wouldn't needed to happen, because they didn't want to spend a few $100s trying to save thousands. And if you're trying to dodge all kinds of probate issues or estate tax issues or all those kinds of things, there are lawful ways to minimize those consequences, and there are ways to horribly enhance those consequences by goofing it all up. So when you're in your mind thinking, well, maybe I should add my grandson to this deed, or maybe I should add my 2 sons to this bank account, call the lawyer, get an appointment with the lawyer, and go over and create a comprehensive plan for everything you're planning to do, because the lawyer can give you all the cost-benefit analysis of doing that. And I wanted to take a moment, too, by the way, remind you, go to weekendappointment.com to sign up for the free wills. And a lot of people who've been getting the free wills have also been asking me about how to get a living will. If you don't have a living will, you're really, really, really putting your family in a bad position, because now they're going to have to decide what your intent was. Did you want heroic life-saving measures, or didn't you want heroic life-saving measures? Did you want to be put on a respirator? Did you want a feeding tube, or did you not? And if you got 3 or 4 or 5 or 6 or 7 kids, there's going to be a difference of opinion most likely between the kids is exactly what you wanted to do, or maybe the grandkids. So I just actually did one not too long ago. I went out and wrote a living will for somebody who's terminally ill. And part of the problem that everybody foresees, or at least that this person did, was that she knows or he knows that their kids can't seem to agree on how to handle end-of-life issues. So by writing the living will, they have completely told the family how to handle the matter. So if you don't have a living will, make sure you get one. When I come back from break, call the talk line, 540-0580. We're going to go to break. And when I get back from break, we'll talk with Hugh and some other folks. Hey, welcome back. Carl Rominger here, 540-0580, 540-0580. If you remember from last week, I had my niece and nephew in here. We went to Hershey Park. So if you go to weekendappointment.com, you go to the announcement section, you can see our exciting roller coaster photo from Sunday's trip to the Hershey Park after the show, or about day after the show. Hugh, you're on WHP 580 with Carl Rominger.
This is Hugh. Am I on?
You're on.
Okay. I have a son that lives in Atlanta, Georgia.
Okay.
And he lives in a condo, old one, with about 1,000 condos, and he can't sell his place because it's too many. And he has they have a high maintenance fee of $475 a month.
Okay.
And he was say his condo is worth so much, and he had to bring down the price. He has a real estate person, and he had to bring it down below what he paid for it.
Right. Makes him upside down in it. Hugh, Hugh, here's our problem.
Wait a minute. I got one other comment. He's stuck with it, and he wants to get out, but then he lives there. He just lost his job in February. He's 46 years old.
If he lived in Pennsylvania, I would tell you what to do.
That's what I'm talking about.
Yeah, but that's what I'm saying. If he lived in Pennsylvania, I would tell you what to do, because I'm just a Pennsylvania lawyer. If you go to weekendappointment.com, in the upper right-hand corner, I've got this link called Legal Match. You'll see it on the top right-hand side of every page. You click on that, post your question through them, and they will get you an answer with a lawyer in that jurisdiction.
It's a Legal Match? What is that?
You go to weekendappointment.com.
Weekendappointment.com.
Yep, and then you just go to the upper right-hand corner where it says Legal Match, okay?
Weekendappointment.com. You don't have any advice on Pennsylvania?
Well, if we were in Pennsylvania, I'd tell them to file a bankruptcy.
Yeah, well, but then he said that,
Hugh.
I suggest he walk away. But then he says that if he walks away, then his 7-year
credit's all goofed up. He's better off to cauterize it with a bankruptcy. Go to weekendappointment.com, my friend. Folks, I can't answer questions from out of state. I'm only licensed for Pennsylvania. So if you're sitting in Maryland and you're about to do something based on something you heard on this show, shame on you. And if you're sitting in Pennsylvania and you're about to do something based on what you heard on this show, shame on you, because you got to run every case by a lawyer. Every case a little different. I get so mad when I go to court and somebody says, I saw that guy and he only got so many days, Mr. Rominger. How come I'm getting more days? And it's the same number of offense. And I'm saying, listen, let me explain what's different. Or we don't know what's different about that case, but every one of them is different. If it were all the same, you wouldn't need lawyers. Jeff, you're on WHP 580 with Carl Rominger. My talk line number is 540-0580.
Yeah, I have a quick question about a company sued me and did nothing. And now a notice to terminate, PARCP 230.2, has been posted. So essentially, from what I understand, this case is going away because they've done nothing in over 2.5 years.
Right, and the court will spontaneously, pursuant to that rule, terminate the case unless they file a notice of intent to proceed.
Right. So they haven't done that, and it's been almost 2 months since they filed this notice. My question involves, can I turn around and sue them for filing a suit and never doing anything?
Not really. Not really. You could have got the suit dismissed on that basis, probably earlier than the automatic dismissal here. But I don't think there's you could only sue them if they had absolutely no ability to sue you, meaning that it was completely in bad faith.
Right. Well, isn't it in bad faith if they don't do anything? They filed a lawsuit, never filed a single motion,
right?
Never brought any discovery, anything.
I guess it would be in bad faith if they agreed it was in bad faith. But here's the question. You're going to say to them, they're going to say, at the time we filed the lawsuit, we were intending to go forward with it.
Okay.
So where does the bad faith come in? And that's the problem.
I'm just saying, but if you just file, so you can file an arbitrary lawsuit against anybody.
No, that's different. They're going to say, at the time, we thought we had a claim against you and we intended to push it forward. You see what I mean? So how do you prove it was in bad faith?
Well, this was for business interference, that I defrauded them, all kinds of bogus claims.
Right. Of course, you didn't do anything either. It doesn't sound like you filed an answer.
No, well, my lawyer said file an entry of appearance and let them make the first claim. Okay?
Well, they must have filed a complaint. Would they file a writ first?
They filed a complaint, and that's it. Never did anything else.
But once they file a complaint, it's your duty to answer. So you're complicit in this because you never answered the complaint.
Right.
Okay. Well, see, that's another problem.
Okay. So you're saying I really can't...
Just forget about it. Let bygones be bygones.
All right.
Although I would have filed an answer that at least said, hey, I didn't do any of that stuff. It's not true.
Okay.
All right?
Yeah, my lawyer just said let them file any kind of motion.
Right, because he's saying let them file a default on you, and then when they file the default, then we'll do it. But they never filed the default.
Discovery that something happened. Okay, they presented no evidence, no nothing. Okay.
Right.
All right. So you're saying.
Sounds like both of you just did nothing with it.
Right. Okay.
All right. That's. What do you care? You won. You know what I mean? That's at the end of the day. That's all. The lawyer logic is. I don't care how we're going to win the case in the sense of whether we win on the merits or a technical motion or the failure of the other side to go forward. You won. Anita, you're on WHP 580 with Carl Rominger. My talk line number is 540-0580.
My husband and I bought a car, paid cash, registered in both our names, but when the title came, it was only in his name. Now, if we keep this car, not that he's going to die in a couple years, but if he would all of a sudden die of a heart attack, the title's only in his name.
Right. So his estate would have to be open to transfer the title to you theoretically or potentially because it belongs to his estate.
But shouldn't the title have been written in both our names
if that's what you wanted, yeah, and maybe you can go back to the dealership and say, "Hey, you guys goofed up. You got to pay to amend this title."
Yeah, okay. I thought about that. Go back that was their mistake, but my husband says it's okay. And today, when I was listening on your call, I thought, uh-oh.
Yeah, it probably is better to get it as joint tenants who right of survivorship. And here's the other deal. Right now, it's technically, let's say somebody sues your husband. That's an asset they can reach. If it's owned by the marriage, then it can't be reached by a third-party creditor. So it's better always for husbands and wives to title things together.
Okay, doke. Thank you very much.
In happy marriages, anyhow.
We've been married 51 years.
All right. Wow, congratulations.
Thank you.
Yeah, that's 51 years. If more people did that, I don't think we'd have a divorce practice anymore, so I'm not sure how I feel about that. Jay, you're on WHP 580 with Carl Rominger.
Hi, Carl. I'm not sure you're going to like this because this is one of those rhetorical questions.
All right.
I tend to think we're a little too litigious in this country these days. I know it's your livelihood. What do you think of the idea that I think is prevalent in some countries, and I'd like to see pushed? If you have a civil suit against somebody,
right,
and you lose, you pay their legal costs. I don't think, especially in frivolous suits, individuals should have to be burdened with the cost of defending themselves.
Yeah, and that's interesting. That's interesting, and I we've debated that as a profession for many years. We lawyers, we don't care. We get paid either way. And some people say, well, there'd be less frivolous lawsuits. But, the problem with that is when loser pays legal fees, and that's generally the position here. And let me ask it this way. Are you saying loser pays legal fees even if they didn't bring the lawsuit?
Well, I'd like to see more things thrown out because I think they're frivolous, but that's my opinion.
Well,
what I would say is if I sue you and I lose, I would pay your legal fee. So
right.
I guess that's,
right.
The person that's bringing the suit
loses.
Loses the suit. I think they should be responsible for taking care of the legal fees of whoever they sue.
But if I sue you and I win, who pays the legal fees?
Then the defendant would
pay their own legal fees.
Yes.
And the plaintiff would still pay his own legal fees.
Yes.
Okay.
Yes. I mean, I'm just looking at cutting back on, I say your workload, but cutting back on the time and expense that is spent.
Well, let me play devil's advocate for a minute and ask you what's clogging the court. Which frivolous cases do you believe are clogging the court system?
Well, I'll give you an example of something that's well known. Remember when the lady sued McDonald's for hot coffee? Selling hot coffee?
That was frivolous.
I think that was frivolous.
Well, did you know?
I don't know all the details.
But let me give you the details, Jay. Jay, you got to hold with me till after break because I want to address this.
That's fine.
Hold with me, brother. Hey, welcome back. Carl Rominger here. Remember, this show is Weekend Appointment every Saturday at 2. I know in the fall we're going to get bumped by Penn State football every once in a while. No, we're not anymore. Is that off, Shane?
We apparently don't have a contract with Penn State anymore, so we are not going to get Penn State football this year on WHP.
Those were going to be the days I was going to hunt on. Oh, no. Well, we'll work something out. All right, Jay, you still there?
Yes, I am.
Okay, McDonald's. Here's the thing about McDonald's. They gave her like $6 million or some crazy amount. And it sounds really stupid, but what the plaintiff was able to produce, McDonald's had 49 incidences of people being scalded by hot coffee. And then they also showed that McDonald's set the exact temperature of the coffee at that temperature that they did. I mean, it's not like when you and I make coffee and we kind of, here's the coffee and we just throw it in the pot. McDonald's knew to a half degree exactly what temperature they were serving the coffee in 2,000 stores. And their own internal memo said, at this temperature, it's going to burn some people, and we have these complaints. But when we make it a little cooler, people don't like it as much. So they intentionally picked a temperature that they knew was resulting in burns, but which sold more coffee. So are you still sure that it's such a frivolous lawsuit? Because now McDonald's actually knocked it back a couple degrees, and now we have less burns happening every year because of spilled hot coffee.
I get the spin. I don't know all the facts.
I know. And I love that case because it's a great example. How we go, it's frivolous lawsuits. Let me tell you something, my friend. Lawsuits are frivolous at times. There are frivolous lawsuits out there, but it's also a great way to protect America from corporate America. The Ford Pinto. Ford said, they blow up, but it'll cost more money to bring them all back than to pay for Johnny's burns.
Wait a second. Now, you're also looking at corporations. What I'm looking at, and I know it's tough because it's hard to split hairs, is more individuals. My neighbor, let's just say my neighbor sues me for looking at him the wrong way.
Do you know what your neighbor's most likely to sue you for? For putting the fence in the wrong spot. or because he thinks the property lines are 6 foot off. Dude, that happens every day. But you know what clogs the court systems? Are you ready? Come up to court with me someday, and we're going to sit around. We're going to see 10,000 criminal cases. We're going to see the district attorney, beating up on some guy for summary disorderly conduct and silly cases. And you're going to see hours and hours of judge time taken up by crazy, stupid, minor criminal cases that nobody can figure out why they were even charged. You're going to see endless divorce litigation. You're going to see endless child custody litigation. I only have Johnny 6.5 days out of every 14, and I need him the full 7, or else I will never be happy, and I need 500 hours of court time. Hey, I don't mind it. Pay me. Or you're also going to see, and here's the number one biggest users of the courts, corporate America. Most of your civil lawsuits are one insurance company versus another insurance company going on for 3 or 4 weeks at a time while they try to decide who pays the $150,000 claim. Is it Progressive's problem? Is it State Farm's problem? Is it Casualty of America's problem?
Have they no other recourse? Can't they come up with a commission, an internal commission that can...
My friend... All your frivolous lawsuits that you're worried about are mainly business on business. I got to let you guys, we got to take people's real legal calls here. And I'm not trying to beat up on you, but...
No, I just wanted to get your opinion. It's enlightening. Enjoy the show.
All right. Yeah, and I only get, and I'm going off only not on you. I'm really just going off in general on this whole, like they're talking about tort reform now. Well, you know what? We could use some medical tort reform. But we always have to be careful because one thing that the American system adjusts, only in America can I go to court and complain about my neighbor, or only in America when the government wants to build something next door to me do I have a recourse to say, you know what, even though you're the United States government, I don't think you should be allowed to do that, and I'm going to challenge it in a court. And that's the one thing. We do have frivolous lawsuits, but it's part of the price of freedom. Remember that.
Maybe you're right there. Okay, well, appreciate it.
All right, Jay. Great talking with you. Folks, 540-0580, 540-0580. I'm Carl Rominger, the show's Weekend Appointment. Make sure you go to weekendappointment.com throughout the week. That's where you're going to get your free will. Dale, you're on WHP 580.
Hello?
Yeah, Dale.
Oh, yeah. Hey, I have a rather strange question for you, I guess.
Yeah.
I'm taking accounting courses in college, and I'm now in contemporary business law.
Okay.
One of the questions we were asked is, what's the difference between venue and jurisdiction?
Okay. I can answer that. Jurisdiction is the power of the court to act. So if the court has jurisdiction over something, there's two types of jurisdiction. There's personal jurisdiction, which means power over the person, and subject matter jurisdiction, which means power over the subject or the matter in controversy. Venue is just where the court has the proper forum, meaning, how do I explain this? So a court can have jurisdiction. So, for instance, a common pleas court in Pennsylvania has jurisdiction over all matters statewide pending in divorce. However, the proper venue may only be certain counties under the rule, and the parties can waive venue. Parties can't waive subject matter jurisdiction. So if a court doesn't have jurisdiction over divorce, even if the parties are in the right county, the court couldn't waive its subject matter jurisdiction. The parties couldn't submit it. So jurisdiction is the concept of power. Venue is the concept of location.
Okay, so then I'm way off.
So the proper venue, you can agree to be in the wrong venue, but you can't agree to be in the wrong jurisdiction if the court doesn't have power. Now, personal jurisdiction you can waive. If you say, this court doesn't have power over me, but I'm going to agree that it does now, then you can waive that. But you can't give courts power that they don't have over subjects. So a certain court, like a district justice court, for instance, can't do a divorce. So even if you and your wife agree to go see the district magistrate and let him or her divorce you, they're not the common pleas court, so they don't have subject matter jurisdiction over the divorce. Whereas you could both go to Erie, even though you're both from Dauphin County, and get a divorce up there because the court, even though it's the wrong venue, you can waive venue, and the court has statewide jurisdiction to do divorces.
Okay.
All right?
I think that gives me an answer on that. Thank you.
Thank you. Mike, you're on WHP 580 with Carl Rominger.
Hi.
Hey.
Hey, my name's Michael, and the question that I have is, my 18-year-old son was involved in an accident. Drunk driver hit him head-on.
Ouch.
And the car was totaled. The insurance company told us that once this woman either pleads guilty or is found guilty of the DUI, we go to full tort. And he said that, now this is the insurance companies telling us that means that we get, pain and suffering, any days that he missed from work, and that goes for him, his passenger, and us. Is this something that I'm going to need an attorney, a private attorney to handle, or is this something that the insurance company will handle? Or?
Mike, I'll tell you what I would do. It's a free consultation, so why don't you come see me? I'd be happy to sit down and talk to you about it, but here's the answer. The answer is maybe, maybe not, but I suspect as nice as they're being to you, yes, because, again, just like my friend earlier, they're not going to tell you about all the coverages. The other problem I have is the insurance company you're dealing with, is that the other guy's insurance company or your own?
Well, this is my own because due to the nature, we decided we'd better go through our own company.
Right.
This is them that's telling us that.
Yeah, and then we would want to make sure that the other, because there's a certain order of how you have to settle things. And you want to be careful that you don't settle with one company and cause a policy exclusion with another. So usually what we try to do is look at all the different insurance policies out there and line up the appropriate order, get all the right consents from the different companies to make sure we can make it work, and make sure you're getting all the maximum dollars available.
Okay.
So, Mike, if you go to weekendappointment.com, you can get my contact information off there. Send me an email would be the best way.
Thank you very much.
All right, my friend.
All right.
Thanks. Yeah, folks, I mean, again, anytime an insurance company is offering you money, I get suspicious. But that's absolutely true. If you get hit by a drunk driver, if the person is found guilty of DUI or enters into the ARD program, you become a full tort person for purposes of your tort selection. But you should be full tort already. If you have limited tort insurance, go see your agent and tell them you want full tort. And by the way, I owe you folks a report on auto insurance. That will be coming, I swear, I promise. Jim, you're on WHP 580. Jim, you're on with Carl.
Yes, Carl. Quick question for you. I was involved in a traffic violation, following a car too close. They gave me a citation. On the citation, the date was wrong by a year, and the fine was wrong by probably about $35.
Okay.
Do I have any rights to file a complaint in front of the district judge because of those two situations?
Well, you can defend that. In other words, you could say not guilty and then go into the hearing and do as I've done and say, after they're all done, say, hey, Judge, I was here to defend what happened on such and such a date, and there's no evidence anything happened on such and such a date, so my client's not guilty. So, yes, Jim, you could win it. Gotta go. There's the music. Folks, weekend appointment. My name's Carl Rominger. If you need a lawyer throughout the week, we have a general practice. We can help you with anything. Go to weekendappointment.com. If we don't do it, we will find you someone that does.